Hi, everyone. Welcome to another episode of the Crickets to Cha-Chings podcast. I'm Julie Berninger, and this is a long-awaited episode that we're so excited about. I have Laura Winston here, who's the principal and chair of the Intellectual Property Practice Group at Offutt Kerman. She is part of a team of lawyers that we work with at Gold City Ventures, and she's here to answer all of our questions about selling products on Etsy in a safe and correct way in terms of IP and copyright. We collected a bunch of questions from our community, and we have Laura here to answer them today. Laura, welcome. We're going to dive right into it.
Thank you for being here. Yes.
Awesome. So first question, let's talk about specific terms that are trademarked. I know in the past I've wanted to make a Friendsgiving item because Friendsgiving is super popular, especially year over year as people are starting to celebrate separate from their families. But is the word Friendsgiving trademarked? Let's kick it off with that.
So the first thing I have to say, and forgive me, but I am a lawyer, is that the information I'm going to be giving is general information that cannot be regarded as advice specific to the situation of the people who are listening in. So addressing that question in rather general terms, I actually, once I saw that this was a common question among your listeners, I took a look at the U.S. Patent and Trademark Office database to see whether there is a trademark registration for Friendsgiving. What I discovered is there are a couple of different pending applications. None of them is registered yet, and that the question really becomes, what are the goods that your sellers are selling? Because the same word can be used as a trademark for different types of goods or services. Think of, I don't know, Dove chocolate and Dove soap, for example. So somebody might be using Friendsgiving to sell one type of product. Someone might want to use it to put it on another type of product. And it might not be an issue. As I mentioned, we can't talk about any specific circumstances, but that's the general principle. When it comes to trademarks, it has to do with what are the specific goods that you are selling, and is there anything the same or similar out there?
So when you're saying it says pending, because I've searched things on that website and I see it a lot, if it's pending, that doesn't mean that you can't proceed with it, right?
It doesn't necessarily mean that you can't proceed with it. Pending means that it has not been formally registered by the U.S. Patent and Trademark Office yet, but within that pending situation, there is a whole lot of things that can arise. It could be a newly filed application where the person who wants to use the trademark isn't using it yet. It could be approved for registration, in use for 10 years or more, and just hasn't reached that final hurdle of that certificate of registration being issued. So pending alone doesn't tell us much. There's more within that record that will tell you what the status of that particular trademark is. If you see that it's in use, that's more significant than if it is not yet in use. If it's been allowed, that means it's been approved by the U.S. Patent and Trademark Office. If it's a newly filed application, we don't know yet what's going to happen with it. So within pending, and I'm sorry to say, because people probably would like a clear answer, there's a lot of variation on what it can be.
Okay, well, it looks like I'd rather see nothing than pending, because pending could mean there's something coming around the corner.
Exactly.
So in terms of when you're saying the Dove chocolate versus the Dove soap example, that makes tons of sense to me. When the person is registered in 15 different areas, that's a little confusing. Like sometimes I'll look and I'll see Friendsgiving, for example, and then you'll see 15 different things. And you're like, how do they have a monopoly on Friendsgiving? Right. Or like what, it's confusing versus Friendsgiving, t-shirts. And if your thing is like, let's say you sell printables and you're trying to make a printable game packet for Friendsgiving that people can pass out and play with their friends, but it says t-shirts, planners, all that random stuff. How do you make sense of that as a seller?
Right. So again, I can't say for sure that, in that specific situation, that the person who wants to make the game would be fine. Generally speaking, a game and a t-shirt would not be considered to be related goods. But again, it depends on so many factors. It depends on how distinctive the word is, if it's a completely made up word versus a commonly used word. That matters. If the party who's gotten the registration is aggressive about suing, that makes a difference whether between that and somebody who is passive about it. So it's not a question that can be answered clearly. And again, one of those situations where there's not a lot of clarity around it. But the general principle is that games would not be considered related to t-shirts.
Okay. Now, just in general, for anyone that isn't aware, most people that have went through the Gold City Ventures program have heard about the U.S. Patent and Trademark Office. But say we have a new listener here. What is this website in general?
So the U.S. Patent and Trademark Office is the government agency that registers trademarks. And in order for someone to get a trademark registration, they have to be using the trademark in interstate commerce, but a person can apply to register a mark before they've reached that point of actual use. There are exceptions for some applicants coming in from other countries, but that would be the subject for, I think, a different podcast. We won't get too much into the weeds on that. When you have a trademark registration, you generally have nationwide rights for that trademark for those specific goods and services. So that is telling if you see something is registered for t-shirts and you want to use the same mark for t-shirts, that's a pretty serious red flag. The website, USPTO.gov, is a place where people can go and just do a quick search. Once you reach that USPTO.gov, you navigate to the page for trademark searching. They recently improved the platform a lot so that you can plug in a term and it'll give you variations on that term. Until recently, you had to plug in the exact words to get anything meaningful. That's a good development. So it can give somebody who's thinking about using a new term a quick assessment of whether there's something dead on out there that's going to be a red flag.
Got it. Okay. I wouldn't say I enjoy searching the Trademark Office website, but I do find it useful.
And that aspect has gotten better.
Yes.
There's still room for improvement, but
for sure. Okay, so next question. This one is always asked. Can I use a song title on a t-shirt or, let's say, a baby shower bundle of products? Could I use a song title?
So generally speaking, song titles are not going to be protected by either trademark or copyright. There could be exceptions. So generally speaking, it's something that a person could use. Now, if their goal is to associate it with a famous pop star, and there are many other aspects that tie it into that pop star, such as a work of art, song lyrics, other indicia that might indicate that star. It's something where there could be a level of concern. Song lyrics alone, generally speaking, are okay. Certain people who are very successful have tried to register their song titles as trademarks. They can't do it for songs, but they can do it for, say, their own line of merchandise. So it's something worth checking on the U.S. Patent and Trademark Office website and through general Google searching if somebody is using it to promote their own products.
Okay. And I think we're going to get into this one a little later, but the examples here, so song title on a t-shirt, I was thinking of ones that I've seen in the craze of the Taylor Swift era. There are a lot of Taylor Swift ones. So we're gonna get into that in a little bit. So we'll just hang on. But let's move on to ask, what about song lyrics? We talked about song title. What about specifically a lyric that everyone loves? Maybe it's a very popular song. Can you put that on a t-shirt? Could you put that on a baby shower bundle of products? I'm using that as a kind of a printable example because we have a lot of printable sellers here. POD would be a t-shirt. Print on demand. So what about the lyrics?
So lyrics are more risky than titles. The reason is that song lyrics are protected by copyright. as a practical matter, if someone pulls out one line of a song lyric and puts it on a t-shirt, can I say that person is going to be safe? No, not for sure. But I think the odds of somebody coming after them and being successful in a dispute are slim. But I would not take an entire song and put it on a t-shirt or a piece of artwork, because those are subject to copyright protection. Generally, they would be registered in the U.S. Copyright Office, which gives the owner, I mean, that's not true of all song lyrics, but successful artists who have managers and infrastructure behind them have likely all registered these song lyrics, positioning them to go after people who are using them this way.
I'm thinking about what I've seen on Etsy. So Taylor Swift has a song, Enchanted to Meet You. Those are the popular lyrics. My kid loves this song. I love this song. We sing it all the time. Mm-hmm. I see those on baby shower products because you can imagine Enchanted to Meet the New Baby is very common, or like a t-shirt with that. What I'm kind of hearing you say is that the less you use of the lyric, the better. But somebody could have already trademarked Enchanted to Meet You. Taylor Swift's team could have already written merchandise Enchanted to Meet You on the USPTO website. So you should always check all of those things to make sure.
Yeah, you summed it up perfectly. Generally speaking, and I can't speak to Taylor Swift or that particular lyric, but generally speaking, taking that song title, if it's not being used for commercial purposes like we discussed, then it's generally not going to be bothered in your Etsy shop.
Mm-hmm. And by not bothered, you mean no one's going to give you a hard time, probably.
Exactly.
So regarding going down this whole, we're going to call it famous pop star, quote unquote, versus just Taylor Swift, because I think all of these questions we could ask about Taylor Swift.
Exactly.
What about if you use an illustration of Taylor Swift? And just to give the audience an example of where I've seen illustrations, I've seen maybe on a t-shirt Taylor Swift's face, but she's a cartoon. She's not actually her. It's not her image or her picture. It's like somebody that drew a picture or took a picture of her and made it into something different with like lines and color and things. Or, in a printable, in print on demand application, a tote bag. That's what I'm talking about. Not her picture, but something that's a drawing of her, where it's clearly her, but it's not her actual picture.
So there's a phrase we use in the legal world that we call name, image, and likeness. And all of those, the owner of the name, image, and likeness has the right to use it how they want. It's also referred to sometimes as right of publicity. And that could give a famous pop star the right to object to an illustration that clearly represents them being used for commercial purposes. It's interesting because whoever made the illustration can protect it as a copyright for their artwork, but could potentially get in trouble for marketing it if it's clearly in association with that particular person. So I would definitely proceed with caution over something like that. And, that may cause some of your viewers of this podcast to say, but I see that all the time. Yes, it's true. Different owners of these rights have different ways of enforcing. Some are more aggressive, some are less aggressive. Doesn't necessarily make it right. So it's just something to keep in mind.
Okay, that makes sense. And I understand this completely. It's a little bit of a bummer because you see the cutest things on Etsy in these categories. Like, for example, on Valentine's Day, my 4-year-old wanted to bring these classroom cards in to exchange cards with her class. And there were Taylor Swift ones that were all illustrations of Taylor in her different outfits that she wore at her concert, which I totally get. This is her name, image, and likeness. That makes sense to me. And the person's taking a risk there. There's so many, to anyone listening who's like, there's nothing good left. We promise you there's thousands of other ideas that you can use to be a successful seller on Etsy without having to infringe on the likeness of a famous pop star. But notably understanding the frustrations there because you see a lot of it.
Sorry to be the bearer of bad news, but that's unfortunately part of my job.
Yeah, exactly. Okay, so the next question, what about a parody on a song title. So it's not the actual song title. Let's say we're making a t-shirt, and what it's going to say is, in this case, in my Swiftie era is one example. That's more the Eras Tour is her tour. So in my Swiftie era, but it could be in the case of Enchanted to Meet You. It could be, I mean, I'm making this up, but like Enchanted to Eat Bacon. I don't know. In that example,
Right.
There's some better twists on famous song lyrics that I'm sure people could come up with. But what about that? What about if it's a song title? And then we'll ask you the name of a concert series, like in my Swiftie era.
So, as I said, with song titles, generally, if they're not being commercialized, they're not likely to be a problem to use it that way. Similar would be if you were to vary it into a parody. I think Enchanted to Eat Bacon people wouldn't necessarily realize it has to do with Taylor Swift. But generally speaking, with a song title, I wouldn't see a big issue with parody.
Okay. And then in the case of Taylor Swift's tour is the Eras Tour in my Swiftie era. And the reason I bring this up, because I look on Etsy right now, and if I was selling print-on-demand t-shirts, I would be very tempted to write in my mom era, because that's sort of the name of a tour. Be in my podcast host era, in my Etsy seller era. There's a lot of ways you can identify yourself and then just add era to it. And people say this to each other all the time. Like I always tell someone something that happened in my day. They're like, "Oh yeah, you're in your mom era." So does that same thing apply as the song title if it's kind of a parody on it?
Generally, the answer is yes. I mean, Swiftie has become such a common phrase. Again, I haven't checked to see whether Taylor Swift herself has gone to try to commercialize Swiftie and, use it for her own branding and merchandise. If she were, I'd proceed with a little more caution. But it's just become such common usage to refer to big fans of Taylor Swift that it's hard to picture that this could be a problem. Again, please don't take this as legal advice. It's just hard for me to imagine based on my experience that would be objectionable.
And Offa Kerman is our lawyer, not necessarily your lawyer who's listening. So you would need to reach out and discuss this with your own group. But this is very educational. So the one thing with the Swiftie era, like Swift is her name, So like groupies, her fans have a body to become their own thing, but it is using her name. So I can see that, like to your point earlier, to look to see has she trademarked Swiftie to produce merchandise and all, or someone else, Is that what you're saying basically?
Yeah. So, and when we talk about fair use in the trademark context, and it's different from the copyright context, but Taylor Swift's name is not protected by copyright. Fair use generally permits the user to use just enough of the name to indicate what it is they're referring to without using more than they should have the right to. So what I mean by that is if you had a picture of Taylor Swift with all of her logos and things that are indicia of her on your shirt, that might not be considered fair use. But just saying in my Swiftie era, you can't mention that you're in a Swiftie era without putting it that way, and that's allowed for the most part.
Cool. And I do want to mention, we're talking in the context here of legal, but we don't know how Etsy technically enables these things. So I just want to mention to sellers, maybe whatever you're doing is okay, but Etsy doesn't have a mechanism to check millions of listings. So they could just swoop down with an algorithm and just say, okay, anyone that has this in their tags or in their title, you're out. So I think that's how they must do it for Disney. They're not like looking for everyone in particular, which Disney don't even breathe and think about doing Disney. I don't know. If you're doing Disney, I don't know what you're doing out there. Disney, Harry Potter, any of those major ones, Marvel, you're going to get taken down on Etsy. It's only a matter of time. And anyone that you see doing it, they're on borrowed time.
Etsy is not going to be liable for any of their users infringing content, as long as they're ready, willing, and able to take things down quickly, as you described, when somebody objects to them being up there. So It is true that by putting something up there, Etsy could, you put it quite well with your description of them swooping down, taking everything down.
Yes, and that I just want to mention it's possible that you are doing something appropriate, but just they don't have a way to individually look at what everyone's doing. So they could be mass doing it. So
Yeah,
I don't
unfortunately,
know
I've
what.
seen that happen with social media sites. Not necessarily Etsy, but over aggressive takedowns because they want to make sure they can maintain what we call safe harbor, where they're not going to be obligated to check everything when it first gets posted, as long as they're willing to take things down. So they can be a little over aggressive at times.
Mm-hmm. Yeah. Okay, cool. So let's talk about trivia games. A lot of people in my community, the Gold City Ventures ePrintables community, sell trivia games because that's a very popular category for printables. And people tend to think of them when they're hosting things at the last minute. But the issue with trivia games is that often the trivia games are not fun unless pop culture is in the game. So, you wouldn't do boring questions and answers. So in that case, though, if you're bringing pop culture into the game, like the names of songs, for example, song artists, sometimes, like for Halloween, for example, you can imagine the trivia game might include famous candies like Hershey's or Twizzlers or whatever. Everyone always asks us, can I use the names of songs and things? And we don't want to, we're not lawyers, so we don't want to give a answer on this. So I was wondering, can you enlighten us? What would you say in that scenario?
So here we come back into that concept of fair use that we were already starting to talk about, and the idea that in the trademark context, at least, it'll be considered fair use generally if you use just enough to indicate what it is that you're talking about, and that would include trivia questions. So you can say, what candy was founded in Pennsylvania in whatever year the company started, and the answer is Hershey. That's perfectly fine. If you had a card that said the answer is Hershey and you branded it with various Hershey logos, just because you felt it would be more popping, that's would could be considered to be more than you need to use in order to make it clear that you're talking about Hershey. So as tempting as that is, I would try to avoid that. But you can certainly ask the questions. I would not print entire song lyrics on the answer for the same reason that we talked about before, that they're copyright protected. And I think there would be an argument that that is not fair use. But you could say, what Taylor Swift song has the line, she's cheer captain and I'm in the bleachers. And and that is not that would be just enough of that to make it so that it would be unlikely to give rise to an infringement claim.
Laura, I think you're a Swiftie. I think you're a Swiftie. Did you go to the concert?
I did not. I was in the same city as a couple of the concerts, but never made it to one.
I didn't get a chance to go either. I kind of regret it. I feel like that was
I
a
can't
moment.
believe the tour is still going on. I just saw that she's in Edinburgh, and I could keep seeing people I know.
Oh, I guess I have a
traveling
chance.
to different cities to go.
Maybe I should do something big like that. Big gesture. Okay, so that is helpful. Next question. We talked about using the picture of the candy in the actual printable itself. Probably not the best idea. Not the best idea. Maybe nothing will happen, but not the best idea is kind of how I took your answer.
Yeah, I would view it as a risk.
Yes. So in terms of, no, this is a tricky thing. For those of us that sell printables, often people buy printables to celebrate events. And an example, let's use the baby shower example. You could give out candy bar favors where everyone who left could, let's say you had the Enchanted to Meet You baby shower or whatever. You would give out a candy, Hershey's bar, I'm just using that as a visual example for people, and then you wrap it in a special wrapper. And maybe you would say Enchanted to Meet You or whatever, thanks, the date of the event or whatever you'd put on it. When someone is buying that on Etsy, they have no idea what they're buying or they can't envision it unless you put an actual candy bar. And sometimes I've seen good mock-ups of like a fake candy bar with no like clear thing it's Hershey's, but the actual customer, in their mind, they're like, you need to tell me, what am I supposed to buy here? Because they're going to be mad if they print out your thing and it doesn't like fit or look good or whatever. And you're like, oh, you were supposed to buy like Mars bars. And the person, it would just been easier to just show like, hey, fits with standard Hershey bars. Because in their mind, that's what they're looking for. They're like, oh, I'm going to give out Hershey bars candies and I'm going to stick this on there. So we as a community were kind of wondering, like, can we put the picture and be like, hey, this fits with Hershey bars candies? on the listing image. Can we do that?
Yeah, so unfortunately, the safer thing would be to do what you've seen people do, which is put a more generic looking candy bar on it, and not use any Hershey imagery in that listing. Again, and I'm not saying specifically what Hershey would do. I am talking more generally about fair use and how going that far, if there's other ways to do it, might not be regarded as fair use by the brand owner, and that brand owner could take aggressive steps. Will they? Quite possibly not. I'm sure you're seeing it a lot on Etsy that they're up there and they're not getting taken down. I'm just identifying where the risks are and what could happen.
Yeah. And in that case, you would like to think that Hershey would say, oh, this person is helping me sell 50 Hershey's candy bars that they didn't sell prior because the person's going to buy a lot for the baby shower to give out. But my point earlier was that you don't know how you technically go about enforcing a trademark. They could just do some type of image scan on like any logo that's theirs and just assume that it's all bad. They're not going to be taking the time to look at your particular thing.
Yeah, generally speaking, in my experience, brand owners aren't really fans of that argument that third party use is going to contribute to sales, because they want to be able to control their mark, and then if they let one person do it, it's harder to control other people doing it. So it seems like a logical argument, but it's not one that brand owners typically
That they
to.
enjoyed hearing.
Yeah.
Okay.
Again,
And I'm assuming
I'm not speaking about Hershey, who I don't work with. I
yes.
don't know, but I'm talking more generally, just using Hershey as an example for
Yep.
illustrative
And then
purposes.
just in general, I'm assuming do you mean social media too? Because there's one thing about listing it on Etsy, right? But you could argue, let's say I want to record a video of, hey, watch me make these 50 baby shower things, and you could show like hands, like sticking a Hershey's bar in there. Is that kind of similar vibe to what you're saying?
Again, I can't say specifically whether that would be okay or not. It depends on which side of that fair use, using just enough of the product to show for your purposes without using too much. That's not something that I really feel I can pass judgment on in this scenario.
That makes sense.
Mm-hmm.
Okay, so we're going to take a little bit of a left turn here, but this has been a very popular trend. I would say it started happening maybe like 4 years ago. People started hearing about art that was vintage art because vintage became big. And anyone that sells on Etsy knows people like vintage. For whatever reason, it was modern, now it's vintage. But reproductions of vintage art, that's kind of something people are getting into. So, what are your thoughts on people selling that on Etsy?
So it depends on the vintage of the vintage. Copyright protection in most cases lasts for a very long time. There are some exceptions, but it's generally either the life of the artist plus another 95 years, or if it's owned by a business, it's 120 years after it's created, meaning if the business is the creator of it. So if it's something like the Mona Lisa, then anybody can sell reproductions of the Mona Lisa to their heart's content. If it's a more contemporary artist, if it's somebody from the 20th century, then there's a very good chance that it's still under copyright protection. As I mentioned, there's some limited exceptions. I don't want to get into again, another podcast that would get pretty legal. But some older art that's less than 95 years past the deceased still is not protected by copyright because of certain requirements that weren't met. So possibly something from the 20th century might not be copyright protected, but many things are. I wouldn't take a Jackson Pollock or like a Basquiat or somebody like that and make a reproduction of that, because that would be copyright infringement. So
some things,
if it's really old, you're fine. A couple hundred years, you're fine. What you'd want to be careful with if you're scooping up a reproduction is to make sure that the reproduction wasn't altered in some way that might give that copyright as well. So
Okay, that's something interesting because what started becoming popular this fall was vintage art of like farm settings, and people would add ghosts to it. I don't know if you saw that, but they would like it would be like an old-fashioned barn, and then there'd be flying ghosts out the windows.
Oh, no, I
And
haven't seen that.
you would see that on social media, and people would directly like paint over the art, and it was like, you're ruining this picture. Like they'd find like pictures from yard sales and stuff, and they'd paint over the art. So I don't know. I mean, now that when you're saying, does that make it more modern? I guess if you were to copy the ghost, you do all of that maybe. So
Right.
is that
If
is
you
that what
were
you're talking
taking a
about though? You mean
reproduction of the entire work, if it was a 200-year-old work and someone paints ghosts on it, now we have a new copyrighted piece of work, and I wouldn't take that entire work without permission from the ghost artists,
okay?
right? And reproduce that.
Okay.
But
And
you
when you
could
say
you could,
reproduce,
yeah.
like there's the physical art of making the picture, but then let's say that you were doing wall art that could be printed at Staples or something, or any store like that. That's the same thing. You're saying reproductions, right? And you don't mean, do you mean like let's say that someone found an old barn or whatever? Are you talking about like what about taking that image and then selling the print, or do you mean like you remade it yourself somehow?
I mean both. In the case of the old barn that somebody finds, they're not going to necessarily know what the copyright story is behind that.
Mm-hmm.
That makes it a little bit tricky. So I was picturing a scenario where people take reproductions of very old art and then maybe alter them or sell them without altering them to be wall art. But if you buy a painting in a garage sale,
Yeah, you don't know.
you don't know. I mean, most likely it's protected by copyright under the law. It may not have been registered by the artist, but doesn't mean it's not protected. And if you just take that and alter it a little and sell it, that could be considered copyright infringement. Again, sorry, we can't be clearer. If you bought a piece of art at a garage sale and it had a date of 1800 on it, and you felt you could rely on that, do whatever you want with it.
Yeah, although you shouldn't. I feel like if something's that old, please don't draw on it.
Right.
Go to one of those shows like Antiques Roadshow and see what's going on there.
See what the value is. Yeah.
So this, in general, though, do you know? We talked about the U.S. Patent and Trademark Office, how there's a website. How would I do this for visual art? Is there like a website for that in the U.S. at least?
It's very, very difficult. First of all, a lot of things you might buy at a garage sale may never have been registered with the U.S. Copyright Office, but it doesn't mean that they don't have copyright protection in it. The Copyright Office website is not, there's very limited search capabilities on it, and you can't search for images at all. You could search things like the painter's name to see if that painter has registered copyrights. Once you do that, you're not going to know, if you find that painter's name, you're not going to know what the artwork is that was registered as a copyright. So, and you can hire the Copyright Office to try to track it down for you. It's very expensive and time and slow, and probably not something that your sellers are really going to be interested in doing. So, unlike trademarks, it's very hard to search for copyright.
Okay, so I'm going to skip ahead to the question, how can I be sure that this artwork I found is in the public domain? What you're saying is that you can, if you know the artist, you can try to search the artist through that same U.S. Patent and Trademark Office. You could try to Google them and see when they were active.
That's true, and that would be like if you found their dates. Really, searching through the Copyright Office wouldn't be that meaningful because a principle that I'm trying to get across is that you don't have to have a registration for your copyright to have rights in it. And basically every original and creative work is either currently subject to copyright protection or was at some time. So the question really becomes, is it out of copyright yet? So the more useful inquiry would be to see the painter, search for those painters' dates of birth and death, and then calculate whether it's been more than 95 years. That's the only way to be completely sure.
Okay, got it. Yeah, that'll be interesting. That could be a whole episode in itself because there are some very popular sellers on Etsy. Those of you that are familiar with North Prints, they're like one of the top ones in terms of producing this vintage art style. And I always wonder, I'm like, is there some searchable database where they're pumping out all this art from? Like, where are they getting it from? You know?
Let me ask you a question because I'm not familiar with that company. Are they doing their own art or are they a site for third parties to post things to sell?
That's an Etsy shop. And if you go on their Etsy page or Etsy shop page, you will see dozens and dozens and dozens of vintage wall art that the person can just download and print at Staples or something themselves.
It's possible that a major shop like that is either getting permission from the original artists. They may not be buying it at garage sales and just doing this. They may be doing it in a way that's not going to get them in trouble.
Yes, although it's Etsy, it's the Wild West out there. I'm not saying anyone's doing anything wrong, but that's why we're having this type of podcast today, because it's a lot of us that are just doing this as side hustles or on the side and needing guidance. So, Laura, we're so glad you're here. Okay, a couple more questions for you while I have you. So we talked about trademark at the beginning, and then we started talking about copyright, and I feel like for people they're like, huh, what's going on?
Exactly.
Can you just quickly explain the difference between trademark and copyright so that we have a basis before asking you the next question?
Sure, I'll be glad to. And one thing I want to say that I haven't said before, because we talked about searching on the U.S. Patent and Trademark Office website, is that there can be trademarks that aren't registered and still have rights in them too. Generally speaking, the rights would be limited to the trading area. So, for example, your local florist with their store name on the front has trademark rights in that store name in the town you live in and surrounding towns, but not nationwide. So just because it's not in the U.S. Patent and Trademark Office doesn't mean someone isn't using it somewhere. Just wanted to get that out there. So trademark protects brands, slogans, various, it can be words or logos, it can even be sounds that are used to sell products and services. Copyright protects original and creative content, whether you're selling it or not. So art, books, some of the printables with original art on them are certainly protected by copyright. And the reason I was saying song titles don't have that protection is because there's a provision in the copyright law that says like short phrases are not protectable by copyright. So Enchanted to Meet You is very unlikely to have copyright protection, but all the lyrics to the song do have copyright protection. That's briefly the difference between trademark and copyright. Copyright protection does not last indefinitely. Trademark protection lasts for as long as you're selling goods and services related to the brand.
Okay, so let's get into the Winnie the Pooh scenario. Winnie the Pooh, this, for context for anyone listening, we all grew up with Winnie the Pooh, Eeyore, Tigger, the whole magical stories. And suddenly, I think in the last year or so, we heard, oh, Winnie the Pooh is coming into the public domain. And everyone was like freaking out, thinking this is going to open up so many more opportunities. You can imagine any type of like kids, printables, t-shirts, merch, bracelets, anything people are selling handmade on Etsy. Maybe now we could include Winnie the Pooh. But never had anyone weigh in on whether that was true or not. So what are your thoughts about this?
So the A.A. Milne original stories, if you ever read them, I read them when I was a child. Those are what people are talking about when they say Winnie the Pooh is now in the public domain, because it was 95 years since A.A. Milne passed and his copyright protection expired. So besides the stories themselves, which are basically now fair game, the artwork in those books, which is very different from the Disney version of the artwork, is no longer protected by copyright, as far as I know. And it's not protected by trademark. Disney, on the other hand, took the Winnie the Pooh and characters. Sure, they originally had some agreement with the A.A. Milne people, and then basically made it their own. So the Winnie the Pooh that you see in Disney looks very different from the Winnie the Pooh in the A.A. Milne books. That Winnie the Pooh is still protected by copyright, is protected by trademark, and so you can't just take Disney's Winnie the Pooh and use that without stepping on Disney's toes on both the copyright and trademark side.
Okay.
Um,
Yeah, to me as an Etsy seller, this would be too much because one, I know that Disney is very dangerous to use. Two, your customers may not recognize the one that is okay. If the face of Winnie is the one that we see with Disney. And then, as I
yeah,
mentioned before, Etsy technically, how can they enforce this easily across millions of listings? They could just not care. Oh, well, I'm using the old one and blah, blah, blah. They like, well, don't care. Just got to take it down.
it could
Um,
be that if somebody just puts Winnie the Pooh in a tag, and I'm not saying this wouldn't be right,
yeah.
but Etsy could do a sweep and take it down, for their own protection, as we were discussing earlier.
Okay. Yep. That makes a lot of sense.
I'm not saying don't do it. I'm just saying with the Milne version, not I would stay away from the Disney. Steer far and clear of the Disney version.
Yes, there's so many
Yeah.
other ideas of things that you can do on Etsy to be successful. Okay, so bringing in the discussion here about trademark and copyright, I want to talk about copyright specifically because on Etsy, this is a fear that a lot of people have, particularly anyone that has got a bestseller. Like they figured out a design, whether it's a particular, maybe it's a baby blanket that they make and they make it a special way and suddenly it's selling. Or maybe you are a digital product seller and you found a hot baby shower sign and it's selling. Or, in the case of your print on demand and you found a t-shirt and it's very unique and it's selling. What can sometimes happen is that somebody sneaky comes up and they will copy your design. Now, there's different types of copying. There's straight up ripoffs where it's like they literally there's like they took my images, they took my listing images themselves, and they're doing them as their own. There's like they recreated it as their own with a new listing image, but that's clearly my design. There's elements of my design that are similar. Like for example, I saw a black and white coupon on one person's shop, and then I looked and the listing that was showing up next to it was a black and white coupon that also had circles. It was very clearly two different designs, but looking at it I'm like, somebody saw somebody's design and decided I'm going to do circles in black and white. There's all different levels of it. So I get these questions a lot, and it's like, can I, and maybe just starting with the printable example, like, can I actually copyright my printable design? Like for example, the coupon, we can use the coupon or as an example if you need one. Could I do that?
So again, can't can't say yes or no in a vacuum. If you've taken something that's original, if you've created a coupon that's original to you and is creative, then it's going to be subject to copyright protection. The way you would want to enforce that protection is to register it with the U.S. Copyright Office, because you can't take somebody to court unless you have that copyright registration. You might think, well, I would never have the budget to take somebody to court anyway. Having that copyright registration positions you to threaten somebody to take them to court and let them know that you have a registration. That's often enough to get them to back down. So in the example where your work is original and creative and somebody copies it exactly, yes, that you do have recourse that way. If you've got that copyright registration, you could easily get Etsy to take it down too, as far as I know. If it's varied to a point where, and again, these situations are the subject of massive litigation all over the place. If it's varied, then it's going to be a question of how similar to yours it is. And one thing I'll throw in there is that if it's something that somebody created without seeing yours, and again, this would be like a question of proof, but happens to look a lot like yours out of coincidence, that's not considered copyright infringement. One of the elements is actually having had access to the work and having copied it. So
would you
people make the same
have to purchase it? Would they? Because I mean, how could you tell from a listing image? Are you saying that they would have had to purchase it probably?
No, they could have just, I mean, a copier, someone who copies it?
Yeah.
They could have seen the image and made the copy that way. It wouldn't
How do
have
they
to
prove
be
that, I guess?
right. Yeah, and again, we're talking these things end up in court with a lot of litigation and a jury that determines. I mean, it doesn't always have to go that way,
Yeah, I mean,
but yeah.
so with the copyright thing, as someone that I've seen a lot of comments about this, and usually a newer seller, particularly in the printable space, they see another thing pop up, and it's hard to tell whether it's a coincidence or not. The case that I gave you of the coupon where the person used circles in the same corners, like it would be hard to explain that away. But that being said, a coupon doesn't really have that many elements to it. Like in terms of number of words on that actual product, and how many different coupons could you have? Like I think the one I saw, it said spa day, and maybe you could add like pedicure or facial. You could give the person you're giving the coupon a choice, right? But then if someone had spa day, pedicure, or manicure, sometimes I'll see newer sellers be like, it was copied. And it's like, oh, I mean, how many different ways can you make a coupon? You know what I'm saying? So,
and changing words, like those words on the coupon really wouldn't be covered by the copyright. Even if you got a copyright, it would be more about the artwork.
and if there's not much art, if it's like just text.
Yeah.
So I guess, are you talking more about maybe like someone did a unique wall art design and it was very intricate, then they could it's unlikely. Are you saying it's unlikely for like simpler printables? Like we're talking about something more complex to actually be covered under copyright?
Yeah, that would generally be the case. Something like a coupon with I haven't seen your specific example, but if you just took a coupon and put a couple circles in the corner and wrote spa day on it,
yeah,
it's questionable whether that could be protected by copyright.
Yeah.
But if you had original artwork of flowers and a woman leaning back in a pedicure chair, well, that if it was original, could likely be protected by copyright.
Right. And you're talking about you drew it. Like, for example, sometimes we have people that come into our world and they're artists and they're like, hey, I'm just trying to make more sales of my art. In that case, if you are a special artist that you do your clip art a certain way and everyone's like, oh, that's not me, but that's a Julie Berninger piece of art. I know that. Then you're more talking about that than like I went on the website Canva and I found a clip art. I don't know if you've used Canva, but it's a graphic design tool and they have thousands of pre-made clip art. If you use a Canva picture of somebody getting their pedicure that a million other people have access to and have used, and then you're trying to say, oh, this is copyright with like 2 words on it, it's unlikely that that's going to stand.
Correct.
Yeah.
Now,
okay.
If you took that, modified it with a lot of originality, combined it with other significant elements, that could be a different story. I'm having trouble seeing all of that fit onto a coupon.
I know. I just kind of like, I feel like in practice, it's not super possible. But let's say someone did want to copyright. And I was on a shop the other day because a lot of us use these tools. eRank is one that I use all the time. Everbee. There's tools for Etsy sellers, and you can use those tools to do many things, like find keywords, but you also can find people that are doing really well. And so I stumbled upon a shop there. And when I went on this shop's homepage, she had at the top, attention creators, I copyright all my designs. And I was like, that is... I just start dying laughing because I'm like, look at her, she's putting I pictured like a castle with like a moat, like she has the whole, the knights all ready.
Right. Hear ye.
Yes, exactly. That's what I was picturing. And I didn't know if it was a bluff. I'm like, oh, like, did you really, I mean, you have like thousands of listings. Did you really copyright all these? And then I'm like, how expensive would that be? Like, you'd have to be a really successful seller to do that. So, just in general, you mentioned the steps briefly. What website would you go on? How much do you think it would cost for someone to copyright it?
So if you have your own original art, sometimes it's appropriate to work with a lawyer on a copyright registration. Sometimes it's very straightforward. If you have your own original art where you haven't used other elements, like you haven't imported Canva clip art, things like that, then it's a very simple and straightforward process to go to it's copyright.gov. From there, you create an account, and then you can follow the instructions to prepare and submit an online copyright application, and the filing fee is about $65. If it's anything more complex than your own original piece of art, it's often good to consult with a lawyer just to make sure you're accounting for things properly, excluding things that aren't original. But for something that's very straightforward that way, your own original art, um,
Yeah.
it's a fairly straightforward process.
I feel like that won't apply to 99% of people because most
Because
people are not
people
artists.
are importing things from other.
Yeah, and I doubt
Yeah.
Canva would be pumped about you
Hmm.
copywriting their clip art
Right.
and
I'm sure it's
things.
in their terms of service that they own the clip art, or, so
Y-
somebody else owns it and not you.
Yeah. Okay, and then, we talked about copyright printables, but just to give some love to the handmade sellers listening, let's say that you make jewelry. One piece I became obsessed with hummingbirds. I'll just let you guys know, like I'm obsessed with hummingbirds. I don't know what happened, but suddenly I'm like into them. Let's say that I got a hummingbird necklace or something. Could I copyright the design of that necklace? Does that make sense?
Uh, Most likely, and if the hummingbird was an original piece, the hummingbird portion could be subject to copyright protection. The necklace would have to have other unique features for it itself to be protected by copyright.
Okay.
For like, I don't know if you can see it, but I just got this
Pretty.
little bracelet. And as pretty as it is, it most likely would not be subject to copyright because it's just like a basic chain with, I think, a rather attractive charm, but nothing particularly new or novel about it. So this particular bracelet would not be subject to copyright. But if there was a a hummingbird charm hanging down from it, that might well be protectable.
Got it. And I will say for anyone listening, don't be discouraged by us saying that these things are likely not able to be copyrighted because there are more than enough good ideas. If you use that mindset, you'll never go about and make a business because anything can be copied at any time, but no one can copy your unique brain and your unique marketing skills. And that's why you're listening to podcasts and you're doing all the things to get better. Someone that is stealing designs is likely too lazy to learn all that things that they're going to make. It's going to make you so much better. And they're just going to move on to the next thing that they copy. So don't be discouraged. Okay. I know, Laura, we're way over.
Within the bounds of these considerations, I agree. Don't be stymied to the point where you don't go forward.
Yes. Okay. So I know, Laura, we're over your time and I have two more questions for you.
That's fine.
Okay, great. So what if something is trademarked in one country and I live in a different country? I know you don't want to talk about specific examples, but Sudoku, just for people listening, if they're like, what is it? Sudoku, I believe, I haven't double checked this, but someone was saying it was trademarked in Japan, but not in the US. And Sudoku is popular for games. So if someone wanted to do something related to that, what would they do if they looked at the search results and it said Japan?
If you're not in Japan, and I mean, yeah, so I'll use that as an example, but again, you can't take anything as legal advice. And also, I haven't verified that that's the case, but assuming it is the case, if Sudoku is only protected in Japan and you're using it in the US and you're not selling to Japan, it's really not a concern. Now, if your website is accessible in Japan, and somebody says, look, you're infringing my trademark, your reaction can be, I don't ship to Japan just because I'm showing it on my website. It doesn't mean it's infringement. I'm not selling there. That, you would likely be okay.
Yeah.
So
Although
for the
you can't
most
stop
part,
Etsy from showing it in Japan, right? So how would you?
exactly.
Yeah.
Mhm.
Okay.
But
So
yeah.
I mean, I think, and we've worked with lawyers at Gold City Ventures a long time. Also, I worked with lawyers in my previous job. Sometimes there's never a clear yes or no answer. There's like how much risk are you willing to accept or
Yeah.
not, right?
Mhm.
So as the business owner, you have to make that choice.
I mean, I'll give a real world example, but it's not in this creative context.
Mhm.
But many years ago, aspirin was declared to be a generic term in the U.S., and any company that makes it can call it aspirin, but it's still a registered trademark in other countries, and only one company can sell it there. So there's your real world example of no one's going to get accused of trademark infringement if it's on an Amazon website in the US and it's not shipping to other countries.
Yeah, and so I guess Grampy takes aspirin every day, put on a T-shirt or something like an aspirin a day keeps
Right.
the heart attacks away.
Exactly.
I don't know what
This
they
is
would
why it
do.
became a generic term in the US because of
Yes,
things
okay.
like that. Yeah.
But I mean, you could just decline shipments to the places that it's like you could just cancel the orders. I guess is that how you're saying
Okay.
like you would physically cancel the orders?
So I'm not familiar with how that works. If
Hmm.
maybe you can designate where you ship to on the Etsy platform.
I don't think you can designate it up front,
Yeah.
but you could always
Yeah.
cancel somebody's order on the back end.
In that case, again, I can't say that there wouldn't be an objection. But if you're
Hmm.
not shipping to those countries, it's not going to be an issue.
Yeah. Okay. All right. And then so we have a last question here. So Laura, there are legal templates that you can buy on the internet. So let's say that somebody was copying you, and you copyright it. You did have something copyrighted, which now we're saying it's kind of rare and unlikely that it's going to work for you to copyright it. But let's say you did, and someone was copying you. You want to send them, I think it's a cease and desist, or you're sending them something. You can buy legal templates. You can buy legal templates for a privacy policy on your website. You can buy legal templates for terms and conditions or whatever. Those are there are people that are selling them. You could Google them and just find them. How do you feel about people using legal templates that are found on the internet?
I would be so wary of using legal templates that you find on the internet or purchase because they're not going to be unique to your specific situation. Yeah, you might get correct terminology for a cease and desist letter that's general enough that you could use it. But you mentioned privacy policy and terms of use. Those are so specific to situations that my firm and I don't do this type of work, so I don't you don't have to. It's not self-serving for me to say this because I don't even do this type of work myself. But I have colleagues who work in the privacy policy and terms of use development space who have to get certifications to prove that they are up to date on the latest rules and laws because it's ever changing. It's going to vary based on the types of information you're collecting, on what type of platform you have in the e-commerce world. I would be very wary of these templates from people who might even be engaging in the unauthorized practice of law by selling templates like this.
They might not be lawyers either.
Yeah.
They could have just
Right.
found a good keyword.
Yeah.
They could
And
have jumped
I
on a
know
good keyword train.
I know that people are concerned about the expense of working with a lawyer. I think there are a number of general business lawyers who would be not budget breaking and who would work within somebody's budget parameters to help them. There are some, you know, arts oriented organizations that help people with limited means when they want to work with a lawyer on something that people could look into. One example is Volunteer Lawyers for the Arts, an organization in New York that operates in New York City. Don't just throw out the idea of working with a lawyer because you're afraid of the expense. Speak with a lawyer and see what it's all about before you give up on that idea.
Perfect. Okay. Well, it looks like we're wrapping up here. Laura, you mentioned that if listeners need further advice on trademark and copyright issues, they can contact you at, can you give your email address?
Sure, it's lwinston, LWINSTON, at offitkerman.com. And Offit Kerman is spelled there. You don't put the PA in the email address, just offitkerman.com. I can be reached there. And I'd be happy to connect with people on LinkedIn. I'm Laura Winston on LinkedIn, so hopefully people can find me there. And
Great. And Offit Kerman, for anyone just listening, is OFFITKURMAN. So, Laura, thank you so much for coming on today. We covered the gamut in terms of copyright, trademark, legal stuff. we're so appreciative, because often when we're navigating Etsy, we're doing this as a side hustle, we're doing it as something on top of caregiving or what day job or whatever else we're going on in our lives. So it's nice to just quickly get the information that we need to feel more confident in selling. So thank you so much for coming on today.
My pleasure.
All right, great.